Greetings, this recording is for Liberty University, Class 343, Professor Aaron Lockhart, Employee and Labor Relations. Next slide. My name is Sean Lumsden, PHR, currently work for Excelis as a Human Resources Business Partner with my primary focus on labor relations, thus my interest for this class, and I'm going to be talking about Case 6. Next slide. So the content of the case, we have a grievant who was a 410 employee, normally scheduled to work a Tuesday through Friday schedule, as illustrated in the graph below on your chart, on your slide. However, there was a Labor Day holiday, and it occurred on the Monday and is typically observed on the following day, so it would have been the Tuesday, the first day that our agreement was due to return to work. However, the employee called in on that Tuesday at 11 p.m. to request a paid personal day, which was also denied for the following day. So in summation, what occurred was that the employee worked the pre-day, the pre-holiday, the qualifying day, the last Friday, but did not work the post-holiday, the qualifying day, that Wednesday, because he had assumed that he had a paid personal day, even though it was actually denied. So next slide. So we have the CBA language, Article 7 and Article 23. 7 talks about the holiday pay and how it's to be applied, and Article 23 talks about the awarding of 4 paid personal days. Next slide. So first thing to talk about is the past practices. So the company has 2 past practices that are applicable to this case, and that is that holidays occurring on Mondays are observed on the Tuesdays, and that personal days requested in advance of 1.5 hours of the start of the shift are always approved. We got to make some assumptions, and that is that the personal leave days haven't qualified previously for any qualifying factors. The notification of the denied personal leave was done timely and promptly. Arnett's call-in was done in excess of that 1.5 hour threshold, and Arnett wasn't paid for the personal leave day either because it was denied. And that the grievance is a third step in pending arbitration. Why? Because I'm the HR director in this case, and it is now advanced to my level. Next slide. So the question I'm going to be addressing is how would you present your case that John Arnett is not entitled to his holiday pay for the Labor Day, and I'm going to do that by focusing on 3 factors: the right to holiday pay versus negotiated benefit, substantiating the common law of the workplace, and interpreting the CBA. How we do that. So next slide. So right to holiday pay versus negotiated benefit. So the FLSA has clearly shown that vacation holiday pays are not entitlements, they're actually a negotiated benefit. And we can see that further when we look at Teamsters versus Rayco Graining, where an employee had negotiated for this benefit with the Teamsters and failed to meet the qualifying factors, and an arbitrator said that he still should receive his holiday pay. However, the 8th Circuit Court of Appeals determined that he doesn't, and the reason for that was because there was unambiguous language in the CBA, which I'll talk about in a moment. So next slide. Substantiating the common law of the workplace. At the very bottom of your slide, you'll see that I have the test that illustrates how we determine that. However, in this case, I will say that both of the past practices are substantiated. They are past practices and accepted. But we need to look at the 3 categories of that, and that is that whether it is contract clarifying, independent, or contract conflicting in regards to this situation. So next slide. So we look a little bit further at the language, and I do believe that when we look at the language, it is plain, clear, and not ambiguous, and we can do that by simply taking a test to it and determining that when we read the language, especially that first Article 7, it can't be interpreted in 2 or more ways. So when we do that, we know that it is not ambiguous. Next slide. Looking again at that language content, and what I want to focus in on is the 3 words that I have selected at the bottom of your slide: may, shall, and will. So may implies permission, shall denotes compulsion, and will implies the future tense. So what we're looking at with those is how to interpret the use of those 3 specific choices of terms in the CBA. So next slide, we look specifically at the articles. So Article 7 reads, the employee shall have worked his full scheduled work day immediately before and immediately after the holiday, which implies that he must do this. They provide the only exception, so exception for proven sickness or injury. So that is the only exception that the employee may invoke. The shift manager may, however, offer to waive the rule in advance of the holiday, and acceptance thereof of an employee or employee shall be seniority based. So he can offer waiver to this, but it must be based upon seniority, and it must be done prior to the event. And then Article 23 illustrates will, right? It talks about will be entitled to 4 paid personal days. An employee shall or will be entitled to those throughout the course of the year. So let's look a little further. We go into the conclusion for the grievance. So the payment of holiday compensation is not an entitlement. It is a negotiated benefit. And we do stipulate the requirements in the CBA in order to fulfill so that an employee may receive their holiday compensation. Past practices, we do have a past practice on not denying personal leave, right? So that does apply to this specific situation. However, it only applies to the grounds of the paid personal leave, not to the paid holiday. And when we look at that, and if you try to apply the language or the past practices that encompass the paid personal day to the qualification of the paid holiday, we find that it is actually a contract conflicting past practice if it was to be applied that way. However, it is not, simply because the language is unambiguous and does provide the stipulations by which an individual must hit in order to receive their holiday pay. And we do know that the CBA is clear and unambiguous. Why? Because it specifically uses the language shall, will, and may, right, and gives specifically the 2 exceptions that an employee may have to that language. Next slide. So what are the actions for the HR director? Well, it's going to maintain the position on the denied holiday pay based on the merits I've already discussed herein. And I would progress this on to arbitration if the union is not willing to accept our response to their grievance. However, onto that last assumption where I assumed that the grievant was not compensated for the paid personal day because it was denied, I would go ahead and overturn that, pay that paid personal day out, deduct it from the employee's bank. Why? Because of the past practice. And the last slide that you'll see is the references to this case. Thank you very much.